February 20, 2026, marks the Supreme Court's return from its winter recess, and among the pending decisions is a pivotal case that could either affirm the legality of Trump's tariffs or dismantle them as unconstitutional. A ruling against the administration would compel the government to refund American businesses an estimated $140 billion in taxes. At the heart of this legal battle is Learning Resources versus Trump, a challenge questioning whether presidents possess the authority to unilaterally introduce new taxes by declaring national emergencies. Two federal courts have already decisively rejected this presidential prerogative. Congress, anticipating such overreach, proactively legislated against similar attempts by presidents with the International Emergency Economic Powers Act, IEEPA, back in 1977. However, the current administration remains unyielding. Trump's legal team is poised for a final confrontation in the Supreme Court, where 9 justices will ultimately determine whether the taxman suffers a significant setback, or if the president has, in effect, created an unprecedented, unlimited executive power to levy taxes. My name is Guy, and you're watching Coin Bureau Finance. Before we delve into the details, it's important to state that nothing in this video constitutes financial advice. We're simply offering our perspective on the Supreme Court case that could potentially nullify Trump's tariffs and explore its ramifications for markets, inflation, and the broader U.S. economy. If you find our insights valuable, please hit that like button, and let's get started. For the past year, U.S. trade policy has mirrored the erratic movements of an inflatable tubeman, swinging wildly and unpredictably, often causing observers to disengage. So to establish a clear understanding, let's recap the state of affairs in early 2026. The weighted average tariff rate on U.S. imports stands at 14%, with an effective rate of approximately 10% once accounting for importers strategically ceasing purchases of heavily taxed goods. This represents the highest level of import taxation since 1946, a direct consequence of Trump's Liberation Day tariffs announced last April. Trump's tariff regime is constructed upon 3 distinct legal frameworks. To fully grasp the significance of the ongoing Supreme Court case, it's crucial to dissect each one. The foundational layer is the 1962 Trade Expansion Act, specifically Section 232. This statute empowers the president to impose taxes on imports under the guise of national security, forming the bedrock of the existing tariff structure. Critically, this particular section is not under legal challenge in the current Supreme Court proceedings. In February 2025, the administration utilized Section 232 to reinstate a 25% tariff on steel imports and elevate aluminum tariffs to 25%. This action unilaterally terminated the quota and exemption arrangements previously negotiated by countries such as Brazil, South Korea, the EU, Japan, and the UK to avoid these duties. Consequently, from March 12, 2025, their steel and aluminum exports became subject to the full 25% rate. Subsequently, in January 2026, the administration imposed an additional 25% tariff on specific semiconductor imports, again invoking the same national security authority. Layer 2 involves Section 301 of the Trade Act of 1974. This legislation serves as the primary tool for the U.S. to address and counter the trade policies of other nations, particularly those of China. The last 3 administrations have consistently employed Section 301 tariffs as a strategic instrument to precisely target and reduce the presence of Chinese products in specific U.S. markets, thereby garnering bipartisan support. For instance, the impactful 100% tariffs on Chinese electric vehicles and the 50% tariff on solar cells are direct inheritances from the Biden era. Last year, Section 301 was also invoked to threaten tariffs of 50% for critical minerals and 100% for rare earths. However, the administration's own investigation concluded in January 2026 without imposing any immediate new tariffs, a fact that speaks volumes about the extent of U.S. dependence on imports of these vital resources. Regardless, much like the Section 232 tariffs, these particular taxes are not being challenged in the Supreme Court case. This brings us to the controversial third and final layer, which is squarely in the judicial spotlight, the IEEPA, or International Emergency Economic Powers Act. Enacted in 1977, IEEPA was originally conceived to delineate, and more importantly, limit the president's powers in conducting economic warfare. Its intended applications included measures such as asset freezes, banking blockades, and prohibiting transactions with foreign entities deemed objectionable by the White House. To be precise, the law grants presidents the authority to regulate trade transactions during declared national emergencies. Trump's expansive interpretation, however, posits that the term regulate is sufficiently broad to encompass the power to tax those transactions. Thus, all that remained was to identify and declare an emergency, or, as it turned out, 9, given Trump's prolific issuance of national emergency declarations over the past year. Among this new catalog, 2 distinct national emergency declarations have served as direct launchpads for IEEPA tariffs. One pertains to the flow of narcotics and undocumented migrants into the U.S., and a second addresses America's international trade deficits. On this basis, Trump invoked IEEPA to authorize the fentanyl tariffs on China, Mexico, and Canada, alongside reciprocal tariffs applied to virtually every other nation. This extensive array of IEEPA tariffs dwarfs their Section 232 and Section 301 counterparts. By early 2026, these new IEEPA tariffs accounted for the majority of total trade enforcement revenue, generating approximately $130 to $140 billion in 2025 alone. And this massive sum is precisely what is under scrutiny in the Supreme Court. By the way, if you're enjoying this video, consider signing up for our complimentary weekly newsletter. We distill all the most significant developments in markets, macroeconomics, and geopolitics each week, delivered directly to your inbox, often before they appear in our videos. You'll find the link in the description below. Additionally, we've secured several exclusive finance-related deals for our channel's viewers, also free and accessible via the QR code displayed right here. Enjoy! The core of the case hinges on how presidents are permitted to interpret the meaning of regulate within the IEEPA's text. Every previous application of IEEPA has been to regulate trade in the literal, traditionally understood sense of the word, a restrictive sense. It was employed to dictate what people couldn't do: you can't send money to this country, or you can't buy oil from that nation. Trump, however, harbors a fundamentally different interpretation. He is employing IEEPA to impose taxes on Americans, compelling them to pay the government for the privilege of engaging in activities that are otherwise perfectly legal. It's the distinction between stating, you cannot purchase Russian weapons, and you may purchase whatever you desire from the EU, provided you remit 50% to the Treasury. No president in IEEPA's 48-year history has ever attempted to wield the law as a revenue-generating mechanism. This lack of precedent was evident when the Supreme Court heard oral arguments back in November, as government lawyers were unable to cite a single instance of such action since the law's enactment in 1977. This brings us to Learning Resources versus Trump, a case that, having been consolidated with Trump versus VOS selections, now carries the weight of deciding the fate of the IEEPA tariffs and, indeed, the vast financial stakes of Trump's trade war. The court is anticipated to issue its decision following their February 20 conference, though there is no fixed deadline guaranteeing precisely when the ruling will be made public. As we've observed, the government's defense hinges on a maximalist interpretation of the IEEPA's enumerated verbs. They emphasize that the Act explicitly grants the President authority to investigate, regulate, direct and compel, nullify, void, prevent or prohibit transactions. That constitutes a formidable list of powers. The administration's logic posits that the power to regulate inherently subsumes the power to impose a fee. Their core argument is that if the president possesses the authority to outright ban imports, which, when considered, represents an infinite cost, then surely he also holds the power to implement a less drastic measure, such as imposing tariffs. Concurrently, Solicitor General John Sauer engaged in a form of legal acrobatics, attempting to persuade the Supreme Court justices that the tariffs in question are not, in fact, taxes. In his oral arguments, he contended, "These are regulatory tariffs. They are not revenue-raising tariffs. The fact that they raise revenue is only incidental." Meanwhile, Treasury Secretary Scott Bessent has publicly projected that tariff revenue to the Treasury could realistically reach $1 trillion by July of this year. President Trump himself has frequently boasted that the revenue already generated amounts to trillions of dollars, claiming it's making America rich again. Clearly, the incidental revenue is quite substantial, Your Honor. Conversely, seated on the plaintiff's bench is a coalition of importers, spearheaded by the educational toy company Learning Resources. Unsurprisingly, they vehemently dispute the administration's arguments. Their position is considerably less convoluted, essentially amounting to a direct reiteration of the U.S. Constitution. Article 1, Section 8 explicitly states, "The Congress shall have power to lay and collect taxes, duties, imposts, and excises." If the text itself isn't sufficiently clear, this power is unequivocally and exclusively vested in Congress. There is no mention whatsoever of the President possessing such authority. Regarding IEEPA, the plaintiffs contend that the law conspicuously omits any explicit authority to lay and collect taxes or duties. In contrast, other trade laws, such as Section 232, explicitly employ terms like tariffs or fees. In IEEPA, such language is absent. The Congressional Research Service has also weighed in on this matter, highlighting that the fundamental purpose of IEEPA was to restrain the executive branch, which had, for decades, operated unchecked, asserting nearly limitless emergency powers. Congress passed IEEPA in 1977 precisely because lawmakers were frustrated by presidents engaging in audacious actions and escaping accountability through a loophole in the Trading with the Enemy Act of 1917. The final catalyst for Congress was President Nixon's decision to unilaterally abandon the gold standard, freeze prices and wages, and yes, impose tariffs, all without congressional consultation. Congress unequivocally declared, "Never again," and resolved to replace the blank check provided by the Trading with the Enemy Act with a precisely defined and limited list of powers under IEEPA. And here we are, seeing the "never again" law being used to do it all over again, only on a vastly larger scale. Even if one were to entertain a reading of IEEPA that implies it can authorize tariffs, several persistent constitutional doctrines consistently intervene. In a lower federal appeals court ruling, Judge Jimmy Ray pointed out that such an interpretation would directly violate the non-delegation doctrine, which expressly forbids Congress from delegating its own legislative powers to another branch of government. Furthermore, there is the major questions doctrine, a more recent legal precedent stipulating that administrative agencies cannot implement vast economic changes without clear, specific authorization from Congress. In this context, it implies that if lawmakers had intended to grant the president the power to fundamentally reshape the entire economy through tariffs, they would have stated so explicitly. They would not have concealed a massive, multi-billion-dollar taxing authority within the innocuous word, regulate, in a 1977 statute, akin to an Easter egg for a future president to discover. The Federal Circuit Court has already noted that imposing tariffs worth hundreds of billions of dollars annually undeniably constitutes the kind of vast economic and political significance that demands clear congressional authorization. We remain skeptical whether characterizing these hundreds of billions of dollars as incidental will ultimately serve as the administration's get-out-of-jail-free card, especially given that they have already lost this particular argument twice. The Court of International Trade previously ruled the tariffs invalid as contrary to law, and the Federal Circuit Court subsequently upheld that ruling, explicitly stating that the government's interpretation would create a functionally limitless delegation of congressional taxation authority, with no judicially enforceable limiting principle. The IEEPA tariffs are only currently active because the Supreme Court granted a temporary stay while it deliberates the case. Should the Supreme Court side with the lower courts, the government would be obligated to return the money, all $140 billion, or potentially multiple trillions by the president's own estimation. Interestingly, someone within U.S. Customs and Border Protection, CBP, appears to be proactively preparing for precisely this outcome. Last month, the CBP quietly published a new rule mandating a transition to a fully electronic refund system, with a compliance deadline of February 6. This means they are modernizing their refund infrastructure just 2 weeks before a Supreme Court decision that could trigger the largest tax refund in American history. Is this a mere coincidence or a calculated contingency? It's plausible that the civil service has identified the clear warning signs of an impending liquidity event and simply wishes to prevent the paper check system from collapsing under the immense demand. A refund of this magnitude would effectively amount to a substantial, unplanned corporate fiscal stimulus, impacting financial statements in Q3 and Q4 of 2026. This would undoubtedly be fantastic news for the affected businesses. U.S. importers across the retail, auto parts, and electronics sectors would experience immediate cash injections. For companies operating on razor-thin margins, such a refund could represent the critical difference between servicing debt and initiating share buybacks. For retailers, it would translate into enhanced pricing power, enabling them to reduce costs and gain market share. It would certainly be a material tailwind for earnings, assuming, of course, they actually receive the money. But about that refund policy. Under U.S. trade law, if an importer paid the tariff and failed to file a specific protest, their entry officially becomes final after 314 days. Once this occurs, the money is irrevocably lost, even if the Supreme Court later declares the tax illegal. Only importers who proactively filed lawsuits in the Court of International Trade to suspend liquidation are guaranteed refunds in the event that the tariffs are ultimately struck down. To date, over 2,000 protective cases have already been filed by companies that foresaw this potential outcome. However, the vast majority of importers who paid the tariffs, grumbled about them, and did not pursue legal action are left hoping that the CBP will process their claims purely out of benevolence, which is highly improbable given the colossal sums involved. However, an even more profound knock-on effect of the IEEPA tariffs potentially being eliminated is the broader fate of Trump's trade war. The entire edifice of U.S. trade diplomacy, and indeed, a significant portion of U.S. foreign policy would face an immediate collapse. Many of the trade agreements negotiated over the past year, such as those with the EU, Japan, and Canada, were signed under the implicit or explicit threat of these emergency tariffs. They were, in essence, agreements signed with a gun to the head. Therefore, if the Supreme Court removes that metaphorical gun, why would these nations feel compelled to honor the deals? European negotiators are reportedly already drafting demands for renegotiation should Trump lose the case. China, meanwhile, would likely experience a temporary reprieve, and the administration's entire leverage structure would falter. Unless, of course, they have a contingency plan. And apparently, they do. The administration is well aware that IEEPA stands on precarious legal ground and could very well be thwarted by the judiciary. However, they clearly have no intention of conceding defeat. In the event of an unfavorable ruling, there are other existing laws that could serve as substitutes for IEEPA as a tariff launchpad. The first option is Section 122 of the Trade Act of 1974. This statute permits the president to impose tariffs of up to 15% for a period of 150 days to address balance of payments deficits. Unlike IEEPA, which necessitated declaring fentanyl and immigration as emergencies, Section 122 is specifically designed for trade deficits. This represents a cleaner legal fit, which naturally prompts the question of why it wasn't utilized in the first place. The primary drawback, however, is the 150-day time limit. Yet, there's nothing preventing the administration from adopting a rolling emergency model, wherein a new emergency is declared every 150 days to keep the tariffs continuously in effect. Then there's the second option, Section 338 of the Tariff Act of 1930. This is often regarded as the nuclear option. It authorizes tariffs of up to 50% on countries that are deemed to discriminate against U.S. commerce. This is particularly appealing because the administration can interpret almost any foreign policy as constituting discrimination. Therefore, for the White House, the prospect of IEEPA being struck down is likely more concerning for its political and fiscal implications than for its purely legal ramifications. Section 232 and Section 301 remain entirely unaffected by any Supreme Court ruling on IEEPA. This means steel, aluminum, auto, and China tech tariffs will all stay firmly in place. These laws provide a robust foundation. Sections 122 and 338 could readily fill the void left by IEEPA's removal. While total tariff revenue would likely dip temporarily as the administration pivots and processes those refunds, the overarching trajectory of the trade war would, in all probability, remain intact. Data released in January paints a picture of persistent inflation. The Consumer Price Index, CPI, concluded 2025 at 2.7%, stubbornly remaining above the Federal Reserve's 2% target. More painfully, the cost of dining out has surged by 4%. This unequivocally confirms what every small business owner already understands: the tariffs are actively passing through to consumers, and the most damaging effects are beginning to manifest in the real economy. In January, the Federal Reserve's Beige Book described manufacturing activity as soft or flat across most districts. This deceleration has been largely attributed to the so-called tariff hangover. Essentially, last year, companies engaged in panic buying, accumulating billions of dollars worth of inventory to circumvent the impending new taxes. Now, they are contending with overflowing warehouses and have consequently curtailed new orders. This phenomenon has effectively pushed U.S. manufacturing into a functional recession. And yet, paradoxically, if one examines GDP figures, the economy appears to be booming. The U.S. economy recorded a massive 4% growth in Q3 2025. Yes, there's that K-shape again. The upward leg of the K represents the services and tech sector, propelled by colossal AI spending and sustained government stimulus, which largely remains insulated from tariffs because it doesn't heavily import steel or plastic. Meanwhile, the lower leg of the K signifies the goods economy, retail, manufacturing, and logistics, which is visibly struggling under the burden of a 14% average import tax. Equally detrimental, however, is the pervasive uncertainty that has placed capital expenditure on hold. If you're a CEO, it's virtually impossible to commit to a contract to construct a new factory when the price of steel could fluctuate wildly, potentially dropping by 25% or soaring by 50%, all contingent on a Supreme Court ruling. As a result, many businesses are simply biding their time, hoarding cash, and awaiting clarity. The market is currently pricing in a soft landing, an assumption predicated on the rules of the game remaining unchanged. However, the Supreme Court case represents a monumental coin flip that could fundamentally rewrite the entire rulebook overnight, or at the very least, trigger a major disruption to the existing tariff regime, and unleash a blockbuster tax refund. We will undoubtedly discover the outcome soon enough. In the interim, however, you can learn about another significant tax refund that the U.S. government is expected to disperse this year. Yes, another one, in the video linked right over here. That's all from me for now, though. So as always, thank you for watching, and I'll see you next time. This is Guy. Over and out.